Hello friends, welcome back. In the first part of the video on paradigm shift in reassessment regime, a new tangle, we had touched upon the broad contours of the new reassessment regime and some of the related issues that have ultimately landed up in the court across the country. We are back with another set of complex issues being faced by the taxpayer, which has led to spike in litigation due to the non-compliance of the procedure prescribed under Section 148 of the Act. With that background, let us now engage with the panel members and seek their views on certain other interesting issues relating to this topic. Mr. J, since the new limitation of 3 years was coming into force from April 1, 2021, Revenue had apparently no other alternative but to issue notices for assessment year 2013-14 to 2017-18, since the same would have otherwise been barred by limitation after April 1, 2021. What shall then be the fate of all such notices issued by the Revenue for assessment years 2013-14 to 2017-18, even though the Revenue has issued these notices by taking the benefit of extended limitation up to June 30th, 2021?
As you rightly said, the Revenue has actually issued notices for 5 assessment years, to assessment year 2013-14 to 2017-18. And the reason for issuing notices for these 5 assessment years was that the new limitation of 3 years, the lower limitation of 3 years was enacted from 1st April 2021. So for till assessment year 2017-18, since the limitation of 3 years would have expired by 31st March 2021, in haste, the Revenue has actually issued all the notices from assessment year 2013-14 to 2017-18. That is the first point. The second point is, as we see these are 5 assessment years, I think we need to put it in 2 blocks. The first block would be for assessment year 2013-14 and 2014-15. And the second block would be from assessment year 2015-16 to assessment year 2017-18. The reason why I have put it in 2 blocks is that for assessment year 13-14 and 2014-15, the outer limit even under the old law of 6 years expired on 31st March 2020 and 31st March 2021. And therefore, the extended limit of 10 years, which has been enacted from 1st April 2021 by Finance Act 2021, would actually not apply to these 2 assessment years. That is why I have put it in first block. The second block I have kept it at 2015-16 to 2017-18 is, earlier the limitation was 6 years. In the normal course, for example, 2015-16, the 6 years would have expired on 31st March 2022. But since the limitation was brought down to 3 years, these expired on 31st March 2021. So therefore, according to me, these are 2 blocks, and block 1 and block 2. Now the new law of 6 years has been extended to 10 years. But at the same time, under the new law, the limitation has been grandfathered to 6 years. So therefore, in case of second block, for example, 2015-16 to 2017-18, whatever be the outcome of the writ petitions challenging these notices for these assessment years, the Revenue may have an option to issue notices under the new law for these years based on the 6-year limitation period. So for example, notice for assessment year 15-16 can come till 31st March 2022, for 16-17 till 2023, and 17-18 till 31st March 2024. Of course, with the caveat that they will have to justify the new condition of reopening going beyond 3 years. That is, the escapement must be represented by an asset, and that escapement must be more than 50 lakhs. So these, according to me, are the 2 blocks for which the notices have been issued.
From your comments, it seems that dozens of 148 notices issued by the Revenue under old law can be split into 2 blocks. First block comprising of assessment years 2013-14 and 2014-15, and from assessment year 2015-16 to 2018-19 would be the second block. Considering the same, Mrs. Jha, what is the advice to the taxpayer while dealing with these notices, which can be characterized under 2 separate blocks? In other words, what should be the right course of action of the taxpayers against these notices issued after April 1, 2021?
Thanks, Punita. I think you've raised a very pertinent question. And if you see this year's finance minister's budget speech, it says that the litigation needs to be reduced. So the government is conscious of the fact that there are too many litigations in this area of 148 proceedings. And but if you really see, it's just the reverse what is being said in the budget speech. So this 148 new legislation has in fact brought in many cases before the High Court. Today, all the courts in the entire country is facing such litigations. And in fact, in Delhi High Court, if you really see the cause list, every second matter which is there is arising out of this 148 proceedings. So if you really ask me, what are the options which are available to an SSE, whether he should straight away go to the writ court or whether he should still wait and follow that GK and Reichert route and then come to the High Court. So my answer to this question is that irrespective of the assessment year, if legislation has come into force and from 1st April 2021, if a new procedure 148A is there in the Act, then that procedure has to be followed irrespective of the assessment year, whether it is 13-14 or it is 17-18. So in that view, all the SSEs can straight away go to the High Court, challenge the notice in a writ petition. But then the natural corollary which will come is what is the fate of these notices? So there are two things which can happen. Firstly, so for 13-14 and 14-15 is concerned, the limitation expires on 31st March 2020. Even if the SSE loses, then also in that situation, there is no question of this particular years being revived because 6 years time period lapses. But for 16-17 and 17-18 onwards, if the SSE loses and courts come to a conclusion that the old law is applicable, in that scenario, the old jurisprudence which is available will still be applicable. So SSE will get the chance to argue on all the points, be it change of opinion, be it on mechanical sanction under section 151. So all the points, all the case laws which are available under the old jurisprudence will be applicable. So SSEs can weigh and then go to the court after following the GK and right shaft route. So their chances of going in the writ petition will not be lost. And after the procedure which was laid down back in 2003 will still have to be followed. So, but which law will be applicable for 1st June 2020 for notices issued after 1st April 2021 to 30th June 2021? It is only the courts who are seized of the matters can tell us. But so for SSEs are concerned, that's how they have to proceed with their matters.
What are your overall views, Mr. Vora, on this issue?
I think, Punita, in this country, I must preface my submission by saying that litigation is time-consuming, long-winded, and expensive. And there are no clear-cut answers that are available which may help put an end to the litigation at an early date. We are also reading in the press about the government mulling and contemplating issuing of an ordinance to validate the notices that have been issued between 1st April 21 to 30th June 21. I know it's a matter of speculation. We don't know whether or not the ordinance will ultimately be issued, what shape the ordinance will take, but we'll leave that apart for the time being. I think, as I would see it, the question whether you need to approach the courts and what is the remedy that you should avail is largely dependent on a cost benefit analysis that most clients tend to do. Apart from the cost benefit, one also looks at the time frame in putting an end to the dispute. So those are considerations that assessees weigh with respect to the facts of their individual case in order to choose a particular option or to decide on a particular remedy. Having said that, I think the question that arises is that should an assessee, and I am just spelling out the various options, should an assessee, with respect to the notices that have been issued between these dates, straight away go to the High Court challenging the notices as being null and void, having been issued, dehorse the new procedure prescribed under section 148A beyond the timeline provided under this Act, again not having regard to the extended limitation in terms of the Relaxation Act. Now that's one option open. The assessee would do well to weigh the situation in case eventually the writ petition is not to succeed. Then the assessee will either have to submit to the jurisdiction of the assessing officer, follow the GKN route, and if necessary, come back in a second writ petition to the High Court. That's one option. The second is the assessee may consider making a comprehensive reply to the assessing officer, first objecting to the issue of notice on the ground that it is without following the procedure. And I have seen some cases in actual practice where the department has replied saying that we've issued the notice having regard to the Relaxation Act, and please furnish your return and thereafter follow the GKN process. So in that situation, an assessee can choose to file a comprehensive reply and comprehensive objections after receipt of reasons, after furnishing the return of income without prejudice and under protest, claiming both the reliefs: one, that the new procedure has not been followed; alternatively, without prejudice, that the jurisdictional conditions with regard to the old law as spelled out in various judicial precedents are clearly applicable, and therefore the assumption of jurisdiction is faulty or invalid because it is in breach of the settled legal principles laid down in those judicial precedents. So that's the second approach, and I would think that if the assessee decides to avail of the writ remedy at that particular point of time after disposal of objections, that remedy is not lost. That remedy is intact, and an assessee can decide to file a comprehensive writ taking both the stands. The third option, of course, is that the assessee, without knocking at the doors of the High Court, seeks to follow the appellate process, follow the GKN route, the order, there is disposal of the objections, ultimately resulting in an assessment, and he may challenge the assessment both on grounds of legality of assumption of jurisdiction as also on the merits of the additions that may be made in the reassessment. So I think each assessee would do well to weigh the remedy that is available in the light of A, as I said, the cost benefit analysis, B, the likely time frame within which the assessee seeks to put an end to the dispute. Having said that, I think this is an individual choice, individual prerogative. We as counsels can only suggest to the assessee the process that needs to be followed, keeping in mind the objective when the assessee seeks to approach a counsel for deciding on the course of action.
Although, as per the memorandum explaining the provisions of Finance Bill 2021, new system was expected to result in less litigation and assist in ease of doing business to the taxpayer, as there is a reduction in the time limit by which a notice for reassessment or recomputation can be issued. However, there is no clarity in the statute as of now with respect to the applicability of these amended provisions to the 148 notices issued during the extended time period up to June 30th, 2021. Many writ petitions have been filed recently to challenge the validity of notices issued by the taxpayer after March 31st, 2021. The amended section seems to defeat the intended purpose of the new legislation to be less litigation prone by inviting fresh stream of litigation in the future unless clarified at the inception itself. With this, we have come to the end of this session. We hope you have found the current session engaging and insightful. Stay tuned for upcoming sessions of Tax Mantra with more such interesting topics. Thank you.